Hello, everyone, and welcome to Thursdays Live with Chug. Each week, we cover pressing topics that matter to you and your business. My name is Arianna Gonzalez, and I'm the Client Services Manager here at Chug Attorneys and CPAs. Please join me in welcoming partner and attorney Diya Mathews from our New Jersey office and Kaveri Vijay from our New York office. Hi there, Diya and Kaveri, and welcome.
Hi, glad to be here.
Thank you so much for being here. So for today's topic, we're going to be talking about mastering the art of contract drafting. Before we begin, just a quick disclaimer for everyone tuning in. I'd like to remind you all that we are live on YouTube, LinkedIn, and Facebook. This conversation is for informational purposes only and does not create an attorney-client relationship. So if you have questions, please comment them below or email us anytime at info@chug.com and we're happy to help you out. So let's get right into it. Kaveri, let's kick things off with a quick explanation on why effective contract drafting is so essential for businesses, big or small.
Yeah, hi. Thank you, Arianna. Very good question. Basically what we call commercial contracts, define the terms and conditions of a business with contracting parties such as vendors, suppliers, clients, customers. Clarity in those terms helps us remove confusions and disputes coming forward, and it gives more structure to the whole transaction in terms of avoiding any kind of misinterpretation of terms, and in which time would be involved in resolving such issues which crop up. So basically, it's good for accuracy and clarity. You don't want to spend so much time in confusions and fighting disputes and misinterpretation of terms. Rather, you invest that little time in having clarity, accuracy of legal terms and commercial terms in a contract. And I believe that's why it is important.
Those are great insights. It's important to get it right from the beginning. Thank you for that info, Kaveri. So let's dive into that a little bit deeper. Can you give us some idea, an overview of the essential elements to consider when you're drafting a contract? Oftentimes there are important elements that people overlook. So if you can cover those a little bit, I think it'd be really helpful for our listeners.
Yeah, thank you. Well, let me just put it out first. There are different kind of contracts. So of course, we will have to change the framework for each. This is a broad perception of what overall could be a defining principle in each. However, we would have to look at each contract individually. Like employment contract would be very different from a commercial contract. That would be very different from an investment agreement. However, what we need to look at is, say, for business purpose, we sign multiple commercial contracts. One of the few, apart from the legal aspects that of course we would have it in, otherwise it would be an invalid contract, considering all that is incorporated. I believe, first of all, you should very clearly define the purpose of the contract. What is that the parties entering into the contract have decided to agree upon, on account of which they have entered that contract. So the purpose should be clearly defined, whether sometimes we come across terms like party A has desired to hire party B for provision of services. Now, services is so broad, like it could be from painting your wall to giving IT services. Be specific. It's very important. Once you know the purpose, then of course scope is very important. A lot of time we have seen, there are disputes and issues pop up because parties just get into the scope. It's an annexure. We forget what we are putting in. Words like getting like one party is committing to the other getting government approvals. Now till the time you get that government approval, you're bound. Instead of using words like getting government approval, use facilitation, facilitating in obtaining government approvals or endeavoring to get it. So these are the specifications we should be very clear about. Scope of work is very important. Only commit to the scope that you can deliver. Read it at least a couple of times before you know what you can and what you cannot do, so that going forward there is no misinterpretation of terms where the other party assumes that this was supposed to be done and we on the other side feel no, but we never agreed to this. So that is another thing. Also, of course, there are multiple clauses, but I'll be going on the more important ones. This is in terms of commercial aspects. And of course, legally, indemnities and damages. One should always remember, like, of course, every party would want to seek these to cover their interest, but please don't go for open-ended indemnities and damages. At least for indemnities, when we have to give it back to another party for claims, they should be capped. Sometimes, because if you leave it open-ended, it could lead to bankruptcy because from your assets to monetary damages, everything can be claimed. So these are some very important aspects that it should not be left open-ended. Capped indemnities, to the extent damages, to what extent one party is supposed to, indemnify, or the other party can claim damages from the other, should be specified. Also, dispute resolution, which I believe Diya will also be talking about in more detail, have to be very clear. Sometimes you've seen dispute resolution clauses having two jurisdictions where the disputes can be fought or settled because they just wanted it to be amicable. Now, this creates confusion because a dispute resolution clause itself means you're coming to the clause when you're in dispute. You will not be looking at each other eye to eye. So have clarity in those clauses, whether you want jurisdiction of courts, you want arbitration, or you want mediation followed by arbitration. These are very clear steps to be considered. And this is where some legal help can also help.
Those are some great insights, Kaveri. It's important to define the purpose and the scope of work and make sure everyone's on the same page with the contract. Diya, can you comment on why clarity in commercial terms is necessary and how it can mitigate contractual disputes?
Sure, Arianna. So that's really law school 101. But because that's what we are taught when we start contracts in law school, right? The first thing is there has to be meeting of minds. The parties have to be agreeing on the same thing, the same terms, and there has to be clarity in what the parties are agreeing on, because then that will, once both sides know what exactly they're agreeing on, that will help prevent misunderstandings later on that can arise due to uncertain language. But when you have well-defined commercial terms, that overall also provides for better legal protection, because in the event that you subsequently have a dispute or the parties can't, see eye to eye, they can go back and they can revisit the terms and conditions. And then they can, even if they don't like it, they might be reminded that, hey, this is what we agreed on earlier when we were preparing this contract. So once they have clarity on what they had agreed upon, even if something seems a little unfair to them, they'll be more willing to abide by it. And so that would help reduce the likelihood of legal battles. And then you can also mitigate risks to a certain extent if you have well thought out, well-crafted contracts, because by explicitly outlining the responsibilities and obligations of each party, the risks can be managed to some extent. Especially on matters such as payment terms, delivery schedules, quality standards, warranties, limitations of liability, right? So these type of issues, if you have clarity in the terms, you can mitigate the risk to a large extent. And then just in terms of expectation management, right? The terms of the contract also serve as a communication tool that sets the expectation for both sides. And that way, both the sides are on the same page regarding the scope of work and, whatever the contract is about. So overall, I would say that, when you have clarity in the commercial terms, that will help foster trust, minimize risk, and promote efficient business operations. Back to you, Arianna.
That's really helpful, Diya. I appreciate your insights on that. We do want to mitigate risk as much as we can, and instilling as much trust as possible is always a great way to go. So, Kaveri, you touched a little bit on indemnity and challenges. So this topic can be pretty complex for non-lawyers to understand. Can you simplify a little bit how businesses should approach these areas in contracts?
Yeah, indemnity and damages will form part of every contract. Even if you're signing off a contract without just thinking it's a legal template and it's okay. They will be invoked mostly when a claim arises by a third party or there has some loss. One of the parties has incurred some loss. So in those situations, yes, when we are signing indemnities, as I said earlier, we have to make sure as a party who's indemnifying the other, what is the scope of that indemnity? What is the quantitative value? We must generally, indemnities should be capped at the value of the contract. It should not be open-ended indirect losses that should be covered through these indemnities. There are different kind of damages. In contracts, sometimes we see one is standard damages, but there are liquidated damages as well. That is on the occurrence of an event. Say you were supposed to complete a timely delivery of a consignment and it did not happen, because of which the other party has incurred a loss. Then on the occurrence of such a loss due to this event, the parties will be liable to pay a damage. Again, this has to be quantified. So there are different kind of damages. One is liquidated damages. One could be punitive, though common law jurisdiction don't really encourage punitive damages, but and indemnities. So basically, they are all there to cover losses if one of the parties has covered it. But the exclusions can be that it should not be open-ended. Most likely it should not always be one-sided only. If there is, both parties are involved, generally there are obligations from both sides towards each other. So it should be ideally mutual, right? It should not be a one-sided indemnity. That's what we ideally endeavor for. But again, depending on the commercial terms and the sector we are in, sometimes we have to give one-sided indemnities. But again, this would be better, at least if you're going through same vendor contracts and templates, then at least the first template we are using, if it is legally vetted by a lawyer, it will certainly help in covering these points up.
Those are great insights on using a good strategy to approach this, and definitely making sure your attorney's looking over them to make sure everything looks good. So let's dive into a little bit resolving disputes in contracts. So when it comes to resolving these disputes in contracts, what are some strategies that can help make the process smoother and more amicable for all parties involved? Do you have some insights on that?
Dispute resolution is a very relevant clause, though sometimes we get drafts without this clause itself, So this, I would say, no matter what, you must have it. It's one of those really, one of the spine clauses of a contract, because tomorrow the assumption when we are signing a contract is obviously not because you want to get into a dispute. Both sides have come together because they see potential with each other to run a business or get profits or revenue or service out of each other. But there's always a risk that things can go wrong, and for that matter we must have a mechanism set in place. So a dispute resolution clause helps to define that process, rather than at that time we are contemplating whether we should go to court, whether we should go to arbitration or mediation. So instead of, first of all deciding what would be the process that one party would be choosing, which now has become a dispute itself, it's always better to have a dispute resolution clause with clarity. And of course, in that, now it will depend on what mechanism you choose for a resolution, depending on the value of the contract. For bigger disputes which run into a lot of money for the company, say 90% of revenues, etc., arbitration, if it's involving parties, foreign parties, or sometimes they insist on having, arbitration clauses, which is much faster and quicker as compared to local jurisdictions where parties are wary of getting into local courts, right? And so these are processes can be worked out depending on the commercial terms and which side, because nowadays contracts, if you see more often than not, are global. Like mostly you'll find one party, one is in US, one is in India, one is in US, one is in Canada, or it could be UK or Dubai. So we are in a global jurisdiction anyway, with so much in a global economy, everything also changes the same way. So we have to see where the protections can be brought, and even if the venue may not be our own local jurisdiction, how we can protect it further.
I appreciate you sharing your insights on that. Diya, I know you have quite a bit of experience on this. Do you have any additional advice on dispute resolution clauses that might be relevant for businesses who are operating internationally?
So again, there's a lot that we can talk about when it comes to dispute resolution. In fact, I always think that before you jump into drafting contracts, it's good to anticipate or have some experience on the litigation side, because that just helps you when it comes to drafting contracts. It gives you a foresight, gives you the ability to, to foresee the kind of problems that can arise. But the good thing is that I think we have all matured now. There are more mechanisms available for dispute resolution. Traditionally, you would jump to litigate something, right? You would go to court, and really litigation should be the last resort because it's expensive, it's complex, time consuming, and you don't have a lot of control. The parties don't have a lot of control over the process because of the legal system and jurisdictions and things like that. So what people have realized makes sense these days is first always try to negotiate. Either negotiate, the parties can negotiate on their own. They can meet directly, have discussions, compromise. Of course, if the negotiations break down, then you move to the next step, which could be these days increasingly becoming popular is mediation. Mediation involves hiring a neutral third party and doesn't have to be a lawyer or a judge or anything like that. The mediator can just be a person who's experienced in mediating business disputes. So it's important that you find a mediator who has experience in business disputes, if that's what you want. And so the mediator will help to identify the common ground, facilitate communications, and will assist in reaching a voluntary settlement. So these days, even when you go to court, sometimes they will just refer you to mediation because the courts understand that sometimes with business matters, it's just a matter of finding common ground. And the good thing is it's less adversarial. The parties can still have a working relationship after going through the mediation process, which you might not necessarily have after litigation, right? So you have a little. It's ultimately it's non-binding, but usually after mediation, the parties understand. If it's a good mediator, I think the mediator will help both sides understand, what their weaknesses are, what the strengths of their position is, and help them, accept the mediator's proposal. So the parties will have a little more control over the final outcome, and it's a little more collaborative. So that's, I highly recommend mediation. And then you can also consider arbitration. Arbitration is a little more formal process where the dispute is resolved by, one or more arbitrators. And the contract will usually have clauses on how the, arbitration will be done, how many arbitrators will be there and where the arbitration will be held and things like that. So that also, it's a little more similar to the court process, but the parties again have a little more control over that. The arbitrator's decision is binding. So that's the difference between mediation and arbitration. So unless you can set aside the arbitral award decision on some specific criteria, it is a binding decision. The other thing to keep in mind when it comes to disputes, you have to make sure, and I think Kaveri referred to this earlier, you have to pay attention to the choice of forum and the governing law, because when you have international business transactions, you want certainty about where the dispute is going to be addressed. Is it a court in, let's say if one party is in England, is it going to be the courts of London, or and the other party is, let's say, overseas in India? Where will you file the lawsuit, right? So that is what is determined in the choice of forum. And then which particular law, which country's law will apply. So that's the governing law clause. So both are important. And so that should also be carefully thought out when you are drafting the contract. So yeah, that's from me on disputes.
That was all really helpful, Diya. I appreciate you covering mediation and arbitration and the benefits of each and how businesses should consider this, before litigation. So thank you for covering that. Just a quick disclaimer for everyone tuning in. We are talking about the mastering of contract drafting, and this live is for informational purposes only. It does not create an attorney-client relationship. So please comment any questions you have below or email us at info@choop.com. Let's get back into our conversation. Kaveri, could you shed some light on the benefits of businesses getting a contract legally vetted and why this is an essential step?
Yes, I think that's really pertinent because most of the drafts are based on legal terms and principles. So there could be some aspects in which when we are signing, we may just look like, okay, just a clause and it's just written standard template, but the implications we may not be able to assess. legally, because the law is dynamic. We have a lot of case laws and precedents which keep coming, which could impact sometimes the whole validity of a clause itself in a contract. So generally, a lot of people come to us even when they are going to get one template. And what helps is when you're using the template with multiple customers or service providers, it does at least make sense that all your clauses are legally vetted, so that one, we know they're all valid, and second, they are in your interest, so that there is no kind of risk that is involved that could tomorrow turn into a liability on the person executing that contract. So that little legal assistance goes a long way in mitigating any risks for later, any situation of disputes or claims that could come on the party itself signing the contract. So that is a little investment that could go a long way. Yeah.
That's really helpful information. Businesses need to make sure they are being protected with the legal terms. So it is important to consult a legal professional to make sure that everything looks accurate and that you are protected. I appreciate you covering the importance of that. So what are some specific drafting strategies that businesses can employ to ensure their contracts are enforceable, but still flexible enough to accommodate the changing business needs? Do you have some insight on that?
Well, the question itself is, I think, very self-explanatory. We are in a dynamic global economy, and we will keep changing with time. Till some time back, it was all contracts, physical contracts. We were only talking of offline businesses. Now every business is online. Of course, they may have physical stores as well, and operations. So what could be enforceable is, one, that we have to keep in mind the changing legal framework of the law. Like e-commerce is a very dynamic aspect of economy, of every economy today. And today, now we have to, when we are drafting an e-commerce contract, we have to consider privacy rules, privacy laws, data protection, any kind of consents that are required to be taken under intellectual property laws, information technology laws. So every sector will have its own demarcation, but e-commerce runs, for example, in every sector, whether it's health, whether it's pharmaceuticals, it could be manufacturing, or it could be retail, right? So these provisions, of course, we must have what the law requires, all the consents that we need to take from customers during data collection, to the extent of whatever we need to disclose to the customers. Everything has to be put in place to that contract be enforceable. So that's the legal framework. We have to make sure that it is in consonance with the legal framework and the legislative, intent and principles. And the second side are commercial terms. Now that will vary from every sector to sector, depending on you are in which industry. You will turn that around according to your industry and sector regulations, and your commercials will also match that. So these are things you have to keep in mind. And I think if you have enough experience, you would know how to cover. But again, it just becomes a little more important that these are legally vetted once again, because law is a very dynamic field, keeps changing every day. We are also like updating ourselves very very thoroughly every day before advising everyone. So this is something which doesn't hurt. I use the word investment. It surely is an investment, but it goes a long way. Yeah.
So as you mentioned, the importance that things are constantly changing. So as we're increasingly shifting towards digital agreements and e-contracts, are there any new considerations that businesses need to be aware of?
Oh, well, like I said, there is a whole legal framework which governs e-contracts, digital contracts, So though that infrastructure, that legal framework has to be incorporated in any digital or e-commerce contract, right? We have to make sure that they are in conformity with that law. Second, of course, as I said, are the commercial terms. So those will be secondary, but they both have to be like married to each other. We can't have something. Of course, we don't want to make a contract so legally heavy that we lose the whole facilitation of the project and the transaction itself. So as lawyers, our role is to, of course, make sure that we give that legal protection, but at the same time, we look at what the intent of the parties is commercially and facilitate that to the extent it is permissible by law, right? So we are here to facilitate the transaction and make sure legally the framework and compliance is complete, and the protections that our clients need are there, right? So in the interest of that transaction, we are there to facilitate. Yes.
Those are some great insights. So as we've talked about, contract drafting is essential for businesses of all sizes. Do you have some insight on some common pitfalls in contract drafting that are usually committed, and how our audience might be able to avoid them?
I think we have touched upon some of them earlier in the discussion, but of course, the most important thing is clarity of terms, right? Mostly these are commercial terms. Sometimes, because we've seen so many contracts in the past, I can say that confusions arise from the scope of work itself, payment terms itself, where the parties agreed that the payment would be for X amount for this much period, but the other party assumed it was an annual payment. So one has to be very clear with and one should read. Sometimes in some contracts, the taxes are put as reimbursements on one side unilaterally, and whereas as per law, if you are supposed to pay that tax, then each party has to pay their own expenses and taxes. So there are some hidden clauses like this which could come over on you, which have to be reviewed. So these are some pitfalls like we see, and which not because these are bad drafting, because they turn into disputes later. And then it's a big investment on attorney fees, legal fees, fighting it out in court, jurisdiction costs, in time and effect. So these are little things, if we take care of from the beginning, it can really protect us going forward.
That's really important for businesses to consider to make sure that they are protected in this process. So we are running out of time. So one last question for you, Kaveri. If a viewer is interested in seeking professional assistance in drafting or reviewing their contracts, what are their next steps?
I would say, okay, first, if you already have put a draft together, that's great. If there are companies, mostly companies do have their in-house counsels, do send that draft over to them, let them have it. If you don't have an in-house counsel team, or you're an individual entrepreneur, then do reach out to a legal professional, to take care of such clauses and of your draft. Who would give comments and finalize things for you. Sometimes a negotiation may be required if it's an ongoing commercial, transaction. And even there, the assistance of your legal team can be taken. So, that would be at once the draft is created. But before, when you're putting the draft together, I think it's always good to sit down with a paper and pencil and put your, what is the purpose? What are your commercial terms? What is the term? Sometimes the term itself is missing. There are auto renewals which get into trouble later. So be very specific of what is it that you want. You want termination is very important. So these are points you must think through before you're putting in your draft. And then once you put that through, it may not, it's as good as going to a doctor, right? For one good checkup. So it doesn't hurt going to a legal professional just to make sure it's in order. And then you are at least going with some conviction. We can't guarantee against litigations and risks. If somebody wants to send us a notice, we have to fight it, then we can't help that. But to the extent possible we should mitigate it, right?
Thank you so much for your insights and your time, Kaveri and Diya, and thank you so much for joining us today. This does bring us to the end of our conversation, so thank you everyone who tuned in. To stay up to date, please subscribe and follow us on Facebook, YouTube, and LinkedIn. And if this video was helpful, make sure to give it a like. If you have any questions, please email us anytime at info@choop.com, and make sure to join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care.
Thank you.